What's up, everyone? Welcome back to the Landlord Chick podcast. So, in this episode, we're going to be talking about sticky situations with tenants. In particular, we're going to be talking about lease questions, legal questions. What are some of the best ways to handle some things? Now, of course, I'm going to preface this by saying when you listen to this, if you have an applicable situation, obviously check your own individual state statutes. What I'm going to be putting forth is a mixture of best practices, but then also it's going to obviously be based on what our laws are here in Wisconsin. I will point out specifically what is a law regulation versus what is just a best practice. But hopefully we can still give you some good ideas on how to handle very sticky situations when it comes to tenants. So in my 17 years or so in this industry, I have seen a wide variety of tenant situations arise. Everything from the happy, oh my gosh, I just got engaged to my boyfriend for 3 years, all the way over to the inconceivable and two tenants killing each other in a unit that I manage. So I have seen everything on the entire spectrum. We've always talked about tenants on this podcast in the sense of the life cycle. Most everything we talk about is about moving in, moving out, screening them, showing them a unit. But we don't ever talk about necessarily what happens like in between and what can arise in between when they move in and when they move out. So in this episode, I want to dive into some of these questions and these conundrums that we often face. Now, as I stated earlier, understand that my response to these situations is obviously layered on top of Wisconsin state law, but I will point out what I do, which is Wisconsin state law versus what is just a best practice that we have adopted. With anything here, obviously check your state statutes to see if your state does have any directives on anything here. One of the most common situations we have as landlords is we have a situation where we have tenants that are moved in as roommates, but they're not related. Regardless of a romantic relationship or not, they are unrelated tenants. So whether it be boyfriend, girlfriend, or just multiple roommates that there's no amorous relationship going on, those are unrelated roommate situations. It happens fairly often that at some point during the life expectancy of that tenant grouping, one or more will want to move out of the unit and move on to greener pastures, get married, whatever it is. They want to exit that unit. They want to exit that contract. So how exactly do you handle that? Well, some of how you handle it might depend on the length of their lease. If they are currently locked on to another long-term lease, most states will tell you it's your option whether you let somebody off of the lease that is a termed lease, meaning it's not just a month-to-month renewal, it's something that's in a set place for X number of months yet. So in most states, it's going to be your prerogative whether or not you allow somebody to be written off the lease. My opinion is, unless of course I have concerns that the one remaining tenant cannot support the unit, I will go ahead and let the tenant be written off. So if I have a situation where I have 3 in a unit, I'm more likely to let the last one be written off because I still have 2 tenants that are remaining in that unit. Now, when we talk about writing them off, that actually does refer to something. When somebody comes to you and says they want to leave a roommate situation, you should have all the parties of that original lease agreement sign a form that serves a couple purposes. First, it removes the leaving tenant from the lease. So it removes the tenant from the lease who is removing themselves from the premises. 2, and this is probably maybe the more important one as far as you're concerned. 2, it should cover that the security deposit stays with the unit. Now, this is something, consult your state statutes first, see if it tells you anything that you have to do differently. But in the absence of state statute proof, you want to have on that form that the security deposit stays with the unit. Do not get involved in, well, I technically paid it because I wrote the check out, or don't get caught up in any of that disorganization and arguing that goes on regarding the security deposit amongst roommates. Leave yourself out of that unless the state statutes say that you cannot. So have on that sheet a line that says the security deposit is staying with the unit, and that when the final tenant surrenders the unit, it will be written, the security deposit will be written out per the most recent lease. You also should probably put in there that you aren't involved in any sort of negotiations regarding if they are going to pay anybody back about anything beyond this sheet of paper. So just clarify that you're not involved in negotiations. You're wiping your hands of that. The security deposit stays with the unit, and it will stay with the unit until the final original tenant basically surrenders. Again, check your state statutes on all of that. Now, in the event that maybe you have a situation where you have a roommate moving out and it's just month to month, are you going to handle it any differently? Well, you might. If there's a sense of urgency from one party about still being on that lease, again, it's totally your option whether or not you sort of bend to the sense of urgency, but maybe one of them is concerned about the other one damaging the unit, or the other one is concerned about the other not paying their rent. There might be the sense of urgency for resolving the situation and just letting people part their own ways as well, because maybe it's been a bad falling out. Well, in this instance, you're still going to use that same one-page form we just talked about. Go ahead and use that same form to get that urgent situation addressed and removed from your plate. Now, if you have a situation where maybe there's not quite the sense of urgency, it's a mutual parting, they trust each other, there's no question about what the other party is going to do, then you can go ahead and just basically wait to issue a lease renewal, whether it be 60 or 90 days, whatever sort of procedure you need to follow per your state statutes for issuing a lease renewal. When you issue that lease renewal, you're doing an entire lease packet, by the way. When you have a roommate change, whether it be someone's added or someone is removed, I highly recommend you do a whole new lease agreement. So that would be the rental agreement with all of its supporting documentation, smoke and carbon monoxide detector, maybe a pet policy if they have a pet, rules and regulations. Include all of those things in there. Make it a brand new lease, because then you're going to have this ironclad proof that, let's say Anna is a tenant who left. Anna was not on the most recent lease. You're going to have ironclad proof of that. A lease renewal is great for many things, but sometimes in court, it's interesting, is lease renewals can have a sort of playful relationship with judges, in the sense of they don't necessarily appear as ironclad sometimes to judges as full lease agreements do. Now, it's not meant to discourage you from doing one-sheet lease renewals, because 99% of the time your one-page lease renewals aren't going to find their way in court anyway. But it's just something to keep in mind that in this particular situation, it's definitely best any sort of roommate change, you do a whole new lease agreement, even if it's just somebody leaving the unit. Now, if somebody comes to me and says, oh my gosh, I need a new lease right now, I don't want to worry about this person XYZ happening, I'm not going to issue them a new lease under the gun. Why do I do that? Well, when I'm under pressure, I'm more likely to make mistakes. A lease is not a document I want to make mistakes on. So for me personally, if there's any sense of urgency, the only option the tenant has is that one-page form. They have to wait until I have more time to put together a lease renewal, a lease packet, a full-blown lease packet. That's my preference. However you want to handle it, it's totally up to you. I just know under pressure, I would be more likely to make mistakes, and that's the last place on earth that we want to make mistakes. Another situation that might arise with actually any sort of tenant, regardless of whether they're married or not, or whatever the situation is, you might find yourself in a situation where you have to let somebody into the unit who is not the tenant. Now, we're not talking about contractors. We're not talking about people that you hire for HVAC or appraisers, or we're not talking about anybody that's involved in your side of the operation. But instead, we're referencing instances where something might happen to the tenant. Maybe the tenant gets in a car accident. Maybe they end up in the hospital. If they don't have anybody on the lease with them, there's likely going to be somebody contacting you to see if they can get access to the apartment to bring some stuff to the hospital for the person. Another situation you might have is somebody might end up in a coma. Somebody might end up dying. Maybe you have a solo tenant who ends up passing away, whether it be in the unit or not in the unit. In all of these situations, you're going to have instances where people are going to come to you to try and gain access to the apartment to either take care of what needs to be done or to bring things to people that need them. In this situation, what I highly, highly recommend you have is you have in your rules and regulations that the only person that is entitled to enter that unit upon request to the landlord is the emergency contact. So in my application, tenants always identify who their emergency contact is. I highly recommend that you put in your rules and regulations that emergency contact that they fill in is the only person that can be given access to the unit in the event that something happens to the tenant. Now, of course, you need to have some sort of proof that the tenant is actually in this position. So whether it be you have a Zoom with a medical professional who is treating the person in the hospital, or maybe it's a situation where there was a car accident, there was a police report. Maybe it's something where the police can kind of corroborate, yes, they were admitted to the hospital. You obviously want to have some sort of corroborating evidence that says, okay, yes, this person is in the hospital for real. It's not just some sort of ploy to gain access to this person's unit. But always identify in your lease that only the emergency contact who the tenant has designated can ask for that type of access. Also, when you are in a situation where you have somebody who is in the hospital or in a coma, whatever it may be, maybe they move to a nursing facility, a rehab facility, whatever it is, I would also make sure the only person you are letting into that unit is that emergency contact. If they have somebody with them, if they're not the emergency contact, I would probably recommend that they stay outside of the unit unless they are married to the person that is going in. Again, talking about these weird distinguishments between what it means to be married to somebody in certain regards and what it doesn't. If they're unmarried, anybody who is accompanying the emergency contact should remain outside the unit. Now, in the event that the tenant has passed away, obviously you want to let more people into the unit. That's totally okay, because basically at that point you have no tenant responsibility in the sense of they're not going to come back for their stuff. Let's just put it that way, kind of bluntly. They're not coming back for their stuff. So in this instance, it's okay to let the emergency contact in and have all these other people in there with them, clearing it out, packing it up, cleaning it up, whatever. That's a different situation. That's totally fine as long as the emergency contact is always there when you open that door and let people in. Always make sure the emergency contact is there. So have some form of documentation in your lease that says that in the event of an emergency, it is only the emergency contact that will be let into the unit. Now, obviously, what might supersede this is if perhaps, let's say the cops show up with a minor and then the minor is with their grandma, who is the next of kin. In that situation, if the child needs stuff out of there and the police are with them, you're obviously going to let the police and the mom into the apartment, or the grandmother, to get the stuff. That's kind of a no-brainer. Anytime you have law enforcement involved in any sort of situation like this, you can be rest assured that there's this idea of what you're doing is legitimate. So there are certain situations where you might not follow that exactly to the T, and that would be one of those. Now, another common situation that we have with tenants is people getting locked out. Pretty normal. It doesn't necessarily happen too much anymore for me because we stopped using locking door handles. I guess this would kind of be like a pro tip. The biggest way people get locked out of a rental unit is the locking knob. So a child leaves, accidentally turns it, an adult leaves, forgets to leave it unlocked for the kid, whatever it may be. I would say over 70% of lockouts are related to locking handles or locking doorknobs. So because of that, I actually removed locking doorknobs of all of my rentals, and I only have deadbolts. I have significantly reduced the number of lockouts immensely. Like, I have probably not even one a year at this point. Like, that's how incredibly rare they are now. But they might still occur. You might still have a situation. Maybe there's a situation where a child thought they had their key for their unit, but they don't. What do you do then? Usually we're not as familiar with kids on the lease as we are the adults. Usually we have more interactions with adults, obviously through showing them the unit, signing the lease, moving them in. We're going to commit them more to memory than we are the kids. Plus, obviously, when kids age up per se, they're not necessarily going to look the same year after year as much as adults will. So, how do you kind of handle this situation? My recommendation is that you have pictures on file of all of the tenants that are going to be living in that property, and that includes the youngsters. The reason you want this is so that if someone comes to you, calls you and says, "Hey, my name is Tyler. I live in the lower unit over at 521 Magnolia Avenue. I need to get into my property. My mom didn't leave her key for me, or I forgot my key." You're going to have that situation. What you can do in that situation is say, "Okay, Tyler, I do happen to have your photo from your mom. So if when I get there, it matches, I'm going to go ahead and let you in. If it doesn't match, I'm sorry, I cannot let you in because I cannot prove your identity." Now kids' days often have school IDs. Even elementary kids are starting to get school IDs. So obviously you can start to use those as well. But I highly recommend that you have a picture on file of every person on the lease for this exact instance, where if somebody calls and says they've been locked out, you have verifiable proof that they are on the lease or they are somebody that lives there. So I highly recommend you have those. Just keep in mind that if you ask for pictures of driver's license and you keep them on file, you have to keep them in a very secured location, which means you'll likely want to keep them uploaded to like a property management software, something like that, where they take responsibility for the files that are uploaded into their system. Don't keep it on your laptop. Don't keep it on a flash drive. Don't do any of that. Have it uploaded to a third-party system, preferably a property management software company, and have it securely uploaded there. And lastly, another common tenant situation that we are often dealing with, and this one actually does deal specifically with married people. I often get the question, actually, I shouldn't say married people. I should back that up. I should say this is something that happens in amorous relationships. So we've got love going on in a relationship. What about domestic violence complaints? Now, I will say domestic violence complaints, you are probably going to have state statutes that regulate how you handle these. Most states nowadays, I believe, have some sort of protections in place for the victim of the domestic violence situation. So if you have a situation, and I'm not going to get into he or she, I'm just going to use very general terms with persons. If one person assaults another in a domestic violence situation, the person who is the victim in most states has the right to stay in that unit without fear of retribution for the action of domestic violence occurring against them. So saying that again, the victim usually has protections in most states when it comes to domestic violence and their ability to reside in a unit. Now, the perpetrator does not necessarily have rights. They obviously have some rights because they're still a U.S. citizen. There's still rights that are applied to them per law. But in regards to what we're talking about, domestic violence protection statutes in most states do not cover the perpetrator. Let's be honest. Why would they? So as far as the perpetrator goes, you likely have a vast sea of options open to you about how you handle this. Now, are you going to get involved? Are you going to get involved if you have two persons in a romantic relationship where one of them has been victimized? Are you going to automatically get involved? No. Couple reasons for that. First is that until it is made your problem either by the victim or by a neighboring tenant who maybe has been hearing things for months, you aren't going to get involved. So either you have the victim approaching you or a neighbor saying, "Hey, I've been hearing this stuff for months. This isn't the first time. It won't be the last time. Something has to be done about this." That's when you might get involved. Otherwise, you kind of enter into a gray area. Now, yes, you have every right to protect the safety, the quiet enjoyment, your right to protect the physical property as well. You have all of those rights. But when it comes to intervening in people's relationships, it gets really, really tricky. That is why with domestic violence situations, unless of course I'm approached by the victim or I'm approached by a neighbor, I don't necessarily get involved in the domestic violence situation. Now, notice I said in the domestic violence situation. If I go into a unit and I see it's fairly well damaged, I'm likely going to take action on that tenant, and that's regardless of whether or not there's a history of domestic violence or not. Maybe they just have crasher parties. Maybe they have kids which are worse than a Tasmanian devil, or maybe there are domestics that happen in there. But that's where my standing point is going to come from of involvement, is only going to be from the perspective of the physical condition of the property, unless of course again I'm brought into it by somebody else. Now, anytime you do anything with anybody who is a victim of domestic violence, or you have a domestic violence situation, just double check your state statutes when it happens to see some things that you might have to do. You know, just thinking outside the box here, and I'm not speaking from experience, but in your state, you might be required to change the locks for the victim within like 36 hours. I don't know. You might have things like that in your state statute. So anytime somebody brings something new to you where there's this indication that there could be some legal ramifications that you're unfamiliar with, check your state statutes, and this would certainly be one of them. Now, unfortunately, in my situation, I have dealt a couple times with domestic violence situations, not just person to person, but also person to child. And those are honestly the more heartbreaking. If you're wondering, and this is also something that I'm kind of lumping into this, I've often been asked, you know, what do you do in a situation where you suspect or you know child abuse? One of the pieces of advice that my grandfather gave me back when I think I was a teenager or something, like I wasn't even committed to real estate yet. But he said to me, the most troubling part of my job as a landlord is I consider myself a mandatory reporter. Anytime I see a child who is in a distressful situation, whether the unit's not being kept up well, or I see evidence that they're maybe able to get into drugs that are lying around the house, or they've been abused by their parents, I consider myself a mandatory reporter, and I report it to the police. That was my grandfather's stance. That is my stance as well. So with children, I approach it differently. I consider myself a mandatory reporter, no different than a psychologist or a teacher, solely because of the fact that other than teachers, we're the only ones that have the most eyes on a child's situation as landlords. So that's why I view it as my responsibility to mandatory report, which I have. I have reported, I think, 3 things in my career. One of them, the child ended up getting removed pretty quickly. The other 2, they weren't removed right away. I think one of them did eventually, and then the third one, they ended up staying, but there was child services involvement for quite a while, if I remember correctly. But I do consider myself a mandatory reporter when it comes to things with children, because I firmly believe that other than teachers, we have the biggest insight into what their home life is, and it is our societal job to protect them. That's kind of a low note to end this episode on. Like, I love ending the episodes on high notes, or at least in a peppy tone, but I don't know how you can necessarily flip that. Like, that's sort of like the lowest low, like the nadir of existence as far as it comes to topics and real estate. But anyway, I hope you guys have a great week. It's been incredibly busy around here, which is why there was a little lapse in an episode posting. I went away for basically 12 days back-to-back real estate conferences, and they were jam-packed days. So when I got back, I had to do some catching up. Some of you have asked me, hey, was it BPCon? No, it was not BPCon. So the first convention I went to was the Wisconsin Realtors Association. That was my first year there. That was a lot of fun. I loved it. The second one is the one you're probably more familiar with if you've been following me for a couple years. It's the Wisconsin Apartment Association, of which I am chairman of. We had our conference just 2 days after the WRA1 ended. WRA1 was 4 days long. My other convention was 3 days long. I had 2 days home in between. My birthday fell like literally right before all of this, so it's just been crazy. So that's why there was a little bit of lapse in the postings. I had stuff pre-recorded, but I just didn't go in there and actually execute it, which was the really crummy part. See, this is where it's all about execution. Like my dad says, it's all about execution, and Henry VIII was right. It's all about the execution. That was a bad joke. If you're a history nerd, you're not going to get it, but that was a very bad joke. Anyway, it's all in the execution. Remember that. You guys have a fantastic week. I will see you next week for another episode of the Landlord Chick Podcast.